What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know.
Hi, everyone. Pete Sardis for The Lawyer You Know. We are back talking about Aiden Fucci. The defense has filed a number of motions. Those motions were tagged as confidential. There's been some issues with those motions through the court. We'll talk about that today. But before we do that, as always, if you enjoy the episode, please give me a thumbs up. If you've enjoyed this series, please subscribe to our channel. And as always, if you have questions and comments, leave them down below. All right, let's get into it. As you know, Aiden Fucci's trial is supposed to start on February 6th. They have a pretrial scheduled on January 20th. We had an episode just recently talking about what I think is going to wind up being a motion to continue this thing, because it's very normal that these types of cases get moved to be continued shortly before their trials are scheduled, because the lawyers recognize something's not ready, or a witness is not available, something of that nature. So we'll see if that happens. But last week, the defense lawyers filed a series of motions. These motions were all marked as confidential in the court file, which is not unusual in and of itself, because the rules of judicial administration here in Florida actually set forth an entire procedure on what you're supposed to do if you're filing documents that have confidential information in them. The rules actually say that if there's confidential information inside of a court filing, you have to notify the clerk of court so that they can either take the entire document and exhibits and mark it as confidential, or if there's only a portion of the filing that's confidential, they'll only mark that specific portion as confidential. And what do I mean by that is this. Let's just say I file a motion and I reference some medical records in the motion, but I attach the records as an exhibit. Now, if I haven't actually spoken about a particular medical condition or something that is confidential in the actual motion itself, then the motion is open for public view, as are the vast majority of the records here in Florida that involve court proceedings, especially adult criminal cases. If now I attached the medical records, those I would identify as confidential, and the clerk would mark them as such and would not give access to people to be able to see those records unless there was a court order or there was some sort of special, series of people. For example, the prosecutor still gets to see them because they're part of the case. So that's kind of how the confidentiality works. And Florida is actually very direct about what is and is not confidential, because the rules actually set forth what is supposed to be sealed as confidential by the clerk's office. And those records generally include medical records, psychiatric, psychological records, pre-sentence reports, things of that nature. They're actually a list of them. Now, the documents that the defense filed last week were marked as confidential by the lawyers, but the clerk of court made a determination that whatever's inside of those motions does not qualify as confidential based on the rules of judicial administration here in Florida. And what the clerk's office did is they filed a notice to the lawyers saying that if you want to maintain the confidentiality of these records, you're going to have to get in front of a judge within the next 7 days and get the court to issue an order making them confidential so that the clerk does not make them public. So that is something that is, I don't want to say strange. It does happen from time to time, but it's interesting in this set of circumstances. I'll tell you why, because it tells us a lot about what is not in those filings. It's not a pre-sentence report, meaning there's no indication that Mr. Fucci is going to be pleading guilty. It is not medical records. It is not psychological records. It is not psychiatric records. So then what can it be? What then would the lawyers believe and would need to be marked as confidential in a court filing that the clerk says is not listed in the rules of judicial administration? So now we're going to guess. My guess is that the motions talk about something that involves the defense of the case, and the court is obligated to give Aiden Fucci a fair trial. And I understand that this is all about, Tristan Bailey and the fact that she was brutally murdered. But ultimately, Aiden Fucci has been arrested and has been charged with these crimes. So for right now, the only persons whose rights really are paramount over anybody else's are Aiden Fucci's, because he has the right to a fair and impartial trial. He has the right to, to have the court consider motions and to consider things in the light most favorable to him. And that's kind of what's going on here. So I think that the defense has filed these motions, and I'm guessing what is inside of them is either something having to do with a witness. Maybe a witness has done something inappropriate. A witness may have lied under oath, or may have produced some sort of testimony that the defense has now determined is absolutely incorrect, or is a fabrication, and they're bringing this information in front of the court to make a determination about whether or not that witness should be allowed to testify, whether the case against Aiden Fucci should just outright be dismissed. I don't know what the details are, because again, the documents are all marked as confidential, so we can't see them. Another thing that might be in these motions, and it might have something to do with the defense's theory, meaning the defense that they're going to present in front of a jury. And again, that may be a matter of confidentiality, because no defendant is obligated to provide notice of a defense, meaning you don't have to get up there and actually put a defense on. Now, if you're going to, and you're going to put up witnesses, you're going to show documents, you have to disclose those if you elect to participate in discovery, which Aiden Fucci has. So if it's something other than if they're going to put a defense on or not, that would not be something that would be an issue. It would, of course, be marked as a regular pleading, and we'd all be able to see it. So there must be, or might be, something inside of those records that talks about their theory of the defense, or if they're even going to put a defense on. The third part about this, I think, that is strange, is the timing. We've got a pretrial on January 20th, and that pretrial is designed for all the lawyers and the judge to get together, and they're going to basically do some housekeeping. How many days do you think we're going to need for jury selection? How many jurors should the court bring in? Are there any motions that are outstanding that need to be heard? Are there any issues that are going to come up during the trial that the court needs to be aware of in advance, so that when those time come in that trial, the court knows to stop the proceedings, rule on a particular motion? I'm expecting that the defense team, as a normal course, is going to renew all of the motions that they filed previously. And I expect the judge, as normal course, to either maintain the rulings that have been maintained previously, reserve ruling, meaning not make a decision until that issue becomes ripe in front of the court at some point during the trial, or unless the defense can provide some additional information that changes the court's mind. They rarely, change their ruling unless there's something substantial that they didn't know before that has now implication in the case, at which point the court obviously can always change a ruling if the parties ask the court to do so. So that is something that I expect to see at the pretrial. So why have these documents been filed under seal last week? The clerk has asked that the court make a decision within 7 days to determine whether or not they should remain confidential. And we have a pretrial hearing on the 20th. So I looked, there does not seem like the defense has actually set a hearing for these confidential records. So I'm not sure what's going to happen there. But at this point, we know we've got a hearing next week. I'm wondering if the defense is going to abandon the confidential filing and just let those records become part of the public realm here in the next week, or if we're going to see a motion in the next couple of days that asks the court to consider these confidential motions either now or at that pretrial hearing to determine whether they should stay confidential. So we'll keep you posted as that happens. Other than that, what I still expect is a motion to continue this trial, either by the state or by the defense. At this point, probably most likely by the defense. And it's going to be something like a witness is unavailable. We haven't had time to really develop something. We've identified some new information that is relevant to the case that has going to have an impact on the interests of justice. This is the kind of stuff that normally has to be brought before the court for the court to consider a continuance, especially at this time, realistically speaking, 3 weeks out from a very big trial that's going to take a lot of resources. So with that, let me know what your thoughts are. What do you guys think is going to be in that sealed record? Like I said, I know it's not medical records, psychiatric or psychological records, because those things are specifically enumerated in the statute as being sealable. I know it's not a pre-sentence report because Aiden Fucci hasn't pled guilty. So it's got to be something other than that that has an impact on the defense, that has an impact on the interests of justice, something that the defense lawyers believe is material to the case, but they don't want the public to know about it. They don't want it to become, something that the media keys in on. So let me know your thoughts. But for now, if you enjoyed the episode, give me a thumbs up. If you've enjoyed the series, please subscribe to our channel if you haven't already done so. And as always, leave me your questions and comments down below, and we'll talk to you soon.